Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, what's the hubbub about No-Poach? Recent antitrust enforcement in labor markets. In 2016, the Department of Justice and the Federal Trade Commission published their antitrust guidance for human resource professionals, outlining the types of agreements and information sharing that could raise antitrust concerns with respect to labor markets. Historically, these claims were brought civilly, but very recently, the DOJ filed criminal charges involving alleged wage fixing and no-poach agreements. Today, we will further explore what led to these criminal charges and what it means for labor antitrust claims going forward. Joining me today is my co-host, Sergei Zaslavsky. Hi, Sergei.
Hi, Christina.
So what are we talking about today?
Well, as you said, we're talking about labor market antitrust and specifically about no-poach and wage fixing agreements.
And why is the topic important?
Well, there's been a really increasing amount of focus in labor antitrust and no-poach and wage fixing agreements in the past 5 years. As you mentioned a few months ago, DOJ made big news by bringing the first criminal no-poach and wage fixing cases. And now, with the new administration in place, there are questions about whether we'll see even more emphasis on labor antitrust. So we figured it would be a good time to check in with an expert and get a download on where we stand in this area of the law.
Yeah, certainly an interesting time in this space. Who's our guest today?
Well, we're very lucky to welcome Megan Gerking from Morrison Foerster.
Great. Well, welcome, Megan.
Hi, Christina. Hi, Sergei. It's nice to be with you today.
Likewise, Megan. Thank you for joining us. Well, when people talk about labor antitrust, a lot of times the discussion starts with the 2016 guidance for HR professionals. So we'll be boring and we'll start there as well. Can you tell us why this somewhat pedestrian-sounding document is so important? What's the big deal?
Sure. And it is hard to believe that it is 2021 and it's almost been 5 years since the guidance was released. In October 2016, DOJ and FTC issued joint guidance in this area, announcing that so-called no-poach and wage-fixing agreements among employers or through third-party intermediaries like recruiters, standing alone or naked, would be treated as per se illegal agreements going forward and could be criminally prosecuted by the DOJ. So, no-poach agreements not to solicit each other's employees, and wage-fixing agreements are those agreements on employee compensation or salary.
And is the per se, you mentioned that they mentioned them that were going to be quote-unquote per se illegal. Was that supported by any court precedent, or was that sort of the DOJ and the FTC saying this is how we're going to view it?
This marked a significant change in policy by the DOJ and the FTC. Such agreements had been charged as civil violations of the antitrust laws by the DOJ in the past. But going forward, after this guidance was issued, DOJ said it would now treat these as criminal agreements. So naked no-poaching or wage-fixing agreements that, in the DOJ's opinion, eliminate competition in the same way as agreements between companies to fix prices of goods or allocate customers, similar to those types of agreements that DOJ criminally investigates and prosecutes as hardcore cartel conduct.
Now, you said that naked no-poach, a wage-fixing agreement, would be per se illegal and could be criminally persecuted. Could you explain a little what you mean by naked? Are there any circumstances where these agreements are not considered naked or are potentially okay?
That's a great question, Sergei. The guidance left open an exception for ancillary restraints. So agreements that are reasonably necessary for legitimate business collaborations. For example, a no direct solicitation provision could be okay where it is contained within employment or severance agreements or is reasonably necessary for M&A transactions, joint ventures, and other legitimate competitor collaborations.
So it seems that, if I were in-house counsel, what I would really want to know about is what's reasonably necessary, what's on the right side of the line and what's going to get me in trouble. Is there any guidance on what that means in practice?
Yeah, and for us antitrust lawyers, we're used to operating in gray areas. So there is some practical guidance that I think can be used by in-house counsel. For example, agreements could be reasonably necessary when there is a broader, legitimate, pro-competitive goal of the no-poach or wage agreement. The no-poach aspect or wage fixing aspect should not be the goal of the agreement. Companies should also try to tailor the application of the provision to relevant employees. For example, employees who may have key know-how, training, or talent, or are otherwise necessary or valuable for the continuation of the business. To the extent that that can be limited or tailored to a very small group of individuals, it's more likely that something like that would be considered reasonable. One other question an in-house counsel may want to ask is whether the agreement includes a no-hire provision. For example, does the non-solicitation provision prohibit these employees from applying to open job postings? I think if that kind of exception, allowing employees to still apply for open positions, but otherwise not allowing for solicitation, would be helpful in that regard.
Anything else that would be useful to consider?
To the extent that companies can limit the duration of the provision, for example, a no-poach provision that applies only during the duration of a contract or collaboration, something like that would be subject to less scrutiny than one that has a long end, or a long tail, that continues to apply after the contract or the collaboration has ended.
Makes sense. So in general, try to make it as narrow as possible, and that will kind of improve your chances of the agencies looking favorably on it.
Yes, exactly. Try to narrow it in terms of scope, of employees, duration, and what you consider to be non-solicitation.
Now, one important question that comes up in almost any type of antitrust analysis is relevant markets. So usually, when we're talking about relevant markets, then we're talking about, some burger joint. The relevant market is burgers. So we're trying to figure out, is pizza in the relevant market? Is it close enough substitute or not? But when we're talking about no-poach agreements, really doesn't seem that it makes sense to look at the markets that way. Could you tell our listeners how we look at relevant markets in this context?
That's a great question, Sergei. Here, the relevant question is the type of labor that is relevant or applicable to the agreement. So, for example, in your example, to which types of employees does the provision apply? Burger flippers with special skills who otherwise can't, maybe they can't make pizzas. That would be one way to distinguish. Or accountants who could work across franchises, like you mentioned. An accountant could work at a pizza place and a burger joint. One other important issue is geographic market. Are certain types of employees hired in a specific state or region, possibly because of state licenses, or could the types of employees be recruited from anywhere, more of a national market? So I think both product and geographic market can differ.
Yeah, interesting. I wonder actually how, the recent proliferation of Zoom will change the geographic market question. Now that it's so much easier to work remotely, there are probably a better argument for some labor markets being more national rather than regional. But we'll see how that question comes out. So you mentioned that the 2016 guidance indicated that DOJ would go after at least some no-poach and wage fixing agreements as criminal violations. What happened with that? Did the DOJ end up bringing criminal cases?
Sergei, the DOJ recently brought two cases in this area, and these are the first of its kind. On December 10th, 2020, DOJ brought an indictment against the former owner of a Texas therapist staffing company on charges of wage fixing. The indictment charges the defendant with participating in a conspiracy to fix wages paid to physical therapists and physical therapist assistants. And on the no-poach front, DOJ indicted its first case on January 7th, 2021. And this case is filed against SCA, an ambulatory surgical center company. In that indictment, the DOJ charged SCA for agreeing with other providers of outpatient surgical center care not to solicit senior level employees.
Was there a defined geographic market in either of those complaints?
In the wage fixing indictment, the DOJ alleged the relevant geographic market covering the Dallas-Fort Worth metropolitan area. So that was more of a local conspiracy. However, in the no-poach indictment, the DOJ alleges a national geographic market.
Interesting. So I guess we can't have both kinds of geographic markets in labor cases, depending on the circumstances. So DOJ started looking for a criminal case to bring back in 2016 and only brought their first cases very recently. Any ideas on why the delay?
I think there could be a few reasons. First, the DOJ made clear in the guidance that they would prosecute these agreements on a going forward basis. So, it could have taken time to find conduct that continued or started after October 2016. Second, criminal antitrust investigations are complicated, and they take time to develop after conduct is brought to the DOJ's attention. And third, I think that DOJ likely wanted its first cases to be strong ones with compelling facts. It wouldn't want to lose on the first cases that it brought.
That certainly makes sense if you're trying to set a new precedent. You want to make sure you have a good case as your lead horse. What is it about these cases that, from DOJ's perspective, made them seem like strong cases, like the good first case to bring?
The allegations in both of the indictments seem compelling. And in at least one of the cases, there appears to be strong documentary evidence of a conspiracy. And the indictments in both cases suggest that there is at least one cooperator, which DOJ could certainly benefit from to help make a stronger case.
And do these cases tell us anything about where DOJ may draw the line between criminal and civil offenses going forward?
These two cases both appear to involve the exact types of agreements that DOJ said it would criminally prosecute. Naked agreements between employers who compete for labor. I do think that DOJ's prior civil enforcement efforts are indicative on this point as well. In 2018, DOJ brought civil case against rail supply companies who'd entered no-poach agreements, and DOJ alleged that those constituted per se violations of Sherman Act Section 1. And the company settled those allegations, but did stipulate to compliance measures. In the settlement, DOJ stated that it was declining criminal prosecution because the conduct had occurred prior to the October 2016 guidance. But those agreements were horizontal and without broader or legitimate need or pro-competitive justification. Since 2016, the DOJ has also filed statements of interest in other cases suggesting differing treatment depending on the circumstances. For example, vertical agreements, according to the DOJ, should be analyzed under the rule of reason and treated as potential civil violations of the antitrust laws. There have been a number of cases involving franchises, agreements between franchisors and franchisees from soliciting or hiring employees of other franchisees. And the DOJ has said that these should be treated under rule of reason, that they're not per se violations. There was also an interesting case, a private class action case against Duke and UNC, alleging that the two universities had agreed not to poach each other's medical school faculty. In that case, DOJ filed a statement of interest arguing that that agreement be subject to per se standard because there was no other justification. And then, in a highly unprecedented move, DOJ took the step of seeking to intervene in the litigation for the purpose of joining the proposed settlement between the parties. And DOJ would oversee compliance with, in connection with that settlement.
Yeah.
That was, DOJ has been very active in this area since 2016, but just had not filed its own criminal cases.
Got it. So sounds, if it's vertical, it's rule of reason. If it's ancillary to a bigger agreement, it's rule of reason. If it's horizontal and standalone, then it's per se. If we are in that per se land, is it always going to be criminal? Is it sometimes civil per se, sometimes criminal per se? Is it just a matter of prosecutorial discretion? What do we expect for horizontal naked agreements?
I think that the DOJ will try to pursue those criminally, but certainly would have the discretion to determine how to treat those in the future.
And you mentioned that DOJ has been very active in this area, both bringing its own cases, intervening in other cases, issuing statements of interest. Is the enforcement in this area expected to change at all with the new administration in place, or is it expected just to continue along the same track?
In the DOJ, criminal antitrust is overseen by a career Deputy Assistant Attorney General, making it typically immune from big policy type changes. However, the Trump administration, under the Trump administration, criminal prosecutions were generally down. Specifically, they really only brought 20 cartel cases each year as compared to closer to 50 under the Obama administration. It's certainly possible that those numbers are not a result of a administration change, but it is possible that the DOJ will be more active in this space going forward. Recently, Acting Assistant Attorney General for Antitrust Division, Richard Powers, indicated that he expects increased criminal enforcement in this area. He did confirm in this interview that investigations into allegations of labor collusion are an increasingly important and significant part of DOJ's caseload. So I certainly think it is likely that there will be more criminal prosecutions in this area going forward. I can't say whether that's a result of the administration change or not, though.
Got it. Any substantive changes you're expecting, or do you think it's just a matter of greater emphasis on enforcement?
In this area of labor, I am not expecting significant policy changes, but I think that enforcement activity could be increasing.
And on that point, so going back to the 2016 guidance, which identified the types of agreements that would be per se illegal. There was also a section on information sharing. Talk about a gray area for advising clients on, what information sharing is okay and not okay in different contexts, what's reasonably necessary. Any updated advice on what information sharing is okay, what parameters folks should be thinking about when they're either sharing information in the M&A context or just as a general collaboration with other peers in the industry for best practices? How should we be thinking about information sharing guidance?
I agree with you, Christina, that it is definitely a gray area. I think that, absent a pro-competitive justification, broader transaction, companies should avoid exchanging specific information about compensation and benefits. I think that in a broader transaction, there are compelling reasons to share information about compensation and salary generally, but companies, I would advise you to seek the advice of experienced antitrust counsel in that area.
Now, there's always ways to minimize risk using clean teams and other ways if you really need to share information to make sure it raises as few antitrust issues as possible.
Absolutely.
Well, Megan, thank you for your time. This is incredibly interesting and timely, especially in light of the recent DOJ enforcement actions. But before we let you go, we always ask all of our guests a few questions, really. The first is to tell us something about yourself, something interesting about yourself that we wouldn't know if we only knew you professionally.
Something that most people don't know about me is that I grew up in Southern Oregon and skiing all the time. And one of my favorite things to do in life is backcountry ski. I love to, that's like one of the trips that I always like to do with my family now that I live in DC full time. But some of my best favorite memories in recent years are with my husband, either heli skiing or powder cat skiing in backcountry. So I don't know that many people know that about me.
Wow. And where can you backcountry ski in the DC area?
Nowhere. Coming from the West Coast, I'm kind of snobby about where I ski.
You still travel out west to ski, haven't explored the icy eastern Vermont slopes?
Not yet.
And do you have any advice for young attorneys, law school students who are looking to do what you do?
I always encourage younger lawyers to be proactive. And if there are things that they want to do, if they see lawyers where they're working either in a firm or government, academic setting, to be proactive and reach out to those lawyers who are doing the types of work that they want to do and ask how they can get involved. I'm always impressed by junior associates and lawyers at all levels who reach out and say, hey, what are you doing? How can I help? I would love to help with you with your work. I think it's hard to turn someone down who's being proactive in that manner.
Agreed. Well, Megan, now our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So, Megan, we used to actually have a physical hat, and we would pick a number 1 through 25 out of the hat. We obviously don't have that, but we will ask you to pick a number 1 through 25.
17.
Question number 17. What was your favorite course in, I guess, either college or law school?
One of my favorite courses in college, and one of the reasons why I have pursued a career in antitrust, was an economics case study class where we studied the DOJ's investigation and prosecution of the lysine cartel and read the informant. I just thought it was really fascinating, the intersection between law and economics and criminal investigation. I thought it seemed exciting.
Did you see the movie as well?
I did see it when it came out.
What's better, the book or the movie?
I like Matt Damon, so I'll take a Matt Damon any day.
Was it an accurate depiction of the book in terms of, you always wonder if it's a...
I think it was pretty accurate. I know that there were some discrepancies, but it did seem accurate in my view.
Well, next on my bucket list to watch, because I have not watched that or read the book, so I will have to do that. Megan, again, thank you for your time today, and to our listenership, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.